But it's all about love today. It's Monday. Don't let hate go in your mind. Love, love, love. And the day turns out fucking beautiful. Like I tell you, the sun's halfway out. He's playing a half a fag today, the sun. But you know what? I don't need the fucking sun. Why? Because we got the sun in our nutsacks, shining on motherfuckers. That's right. No more fucking bowling. We're taking this to the hoop. Oh yeah, that's how we fucking do it on a Monday morning. But here's your Uncle Joey with you. Front and center, 8:30 in the fucking morning out here, banging it out. You think I give a fuck about the neighbors? They could all suck my dick. It's you and me till the fucking wheels fall off. Entiende? There's the weed Pablo Escobar smoked when he blew up the fucking Ochoa's wedding. I like this time that we spent together in the mornings, you understand me? There's nothing like smoking reefer with fucking family, because that's what we are, family. If it wasn't for you motherfuckers, I wouldn't be here. That's why I do this on a Monday morning, to remind you about your goals. Remind you to go out there. Who gives a fuck what they think? Look at my face. If I gave a fuck what they think, I'd be hidden in a fucking cave right now. I don't give a fuck what nobody thinks. Because at the end of the day, they gotta all suck your dicks. You understand me? It's Monday. You got a dream, today is when it fucking starts. If nobody's on board, fuck them too. That's my fucking world. Fuck them too. Fuck them all. Even Cheeto XL. Fuck them too. It's your world, motherfucker, and it's Monday. You could fucking zero in on something, you know what I'm saying? And fuck them all up in the ass. And at the end, you get your fucking revenge, just like the fucking movie. Capiche?
Sweet bitches, here we go. Here we go again. We're sober. I just realized that. We should probably do something to stop that while we're doing the podcast.
The Reader's Digest version is he is given a new judge, a new prosecutor. They're still trying to force him to trial, and this time they say, I'm going to put you in a cage unless you waive your right to counsel or take the plea and accept your jurisdiction. It was either choice A or choice B. I don't know. It's a little fuzzy, but
kind of like they did to Terry and them, huh?
Yeah.
Where they're really kind of ratcheting down is shoot yourself in one of the 2 feet and move on.
Right. So this was his very last appearance, and he's going to be in again in a couple weeks. And this one is probably the most bloody. I mean, they are really, it still sounds civil, but they're really going back and forth at it. It's really pretty entertaining. So just pipe in whenever you want me to hit pause, and I'll just go from there. Cool.
Okay.
All right.
Mr. Estabrook? Yes. You can come on up.
And of course, if you have any, the nice thing about having Robbie here is, of course, if you have any questions about what he was thinking at that moment, ta-da, here he is. So it's great.
Yep. You can go up to that microphone there. Is Jenna here? She's not. Mr. Maswell's standing in for her. You can do this pipe. Yeah, I actually have a permission. Okay. I filed it. Who's Mr. Maswell? He is, he's the person who's in charge of the first deputy under his claim, the person who's in charge of the administration of all of the misdemeanor cases. Okay. For the state. So I got a what I believe toleration to dismiss. There's something, so I have a note here from Judge Roberts on July 15th that you withdrew your waiver of counsel.
Okay, so just to put this into context, they switched judges on him. Judge Roberts was the previous one. And what happened was, a while back, they tried to force a plea on him. Of course, they have no record of it actually being anything close to, other than pointing a gun at him while they did it. And yet every judge after is just like, oh yeah, it's in the record, so you've been arraigned. And obviously this is where it gets hairy. But that's kind of the context of what she just said.
Yeah, and trying to clean it up and make it look as if it was just a civil.
Right.
It's done.
Right.
Yeah. And they're also saying that I rescinded the previous waiver of counsel that I had filled out in order to get out of jail, and I kept on trying to tell them that I never
restate something. Yeah, something that's under force isn't rescinded, it never was, kind of thing. It's
exactly.
Yep.
That's the game being played here too. So here we go.
I did notice that she had written on this document that quoted the defendant rescinded his previous waiver of counsel, but that's one thing I wanted to correct the record about, because I have never authorized a waiver of counsel in the first place, so I'm not sure how I could have rescinded it. I'm still. Well, if you, so you never. Did you want to appear on your own behalf, or did you want to terminate? I'm still trying to make that determination.
Obviously, she just went off on a completely different path there. Dodged it altogether.
I need to be informed of the cause of the proceedings. I'm not yet arraigned. Okay, well, today is going to be the day. Well, hold on a second. Today is going to be, you haven't been arraigned? No, I have not, and I've made that clear on the record.
So just want to say here for note that it sounds like there's no preparation from one judge to the next to this one. Because obviously Robbie's been a huge pain in the neck, and they're not like taking notes and helping out the next one. They're just throwing them to the wolves. Do you think they're...
That's giving them... I think this is feigned. I'm not sure about that, of course, but I'm curious to see how prepared they are to deal with the issues that Robbie's going to bring up.
Yeah.
Because if they're acting like they've never heard of such a thought, and then they're super prepared and they reach to, exactly the expected response, then obviously they, that indicates that they've been prepared.
Yeah, I guess it could be feigned.
Yeah.
I mean, it's kind of funny to just think they'd be so blatantly manipulative, but, I mean, gosh, can't put anything past them. All right, here we go.
And I've also made it clear that what the record says is in error when it says that I have been arraigned. So I still have a clarification. You're only going to take judicial notice that you've been arraigned if that's what the record reflects. Objection, one clarification. How can you say that I've been arraigned when I've not been informed of the cause and nature of the proceedings? Taking judicial notice of the record when you see what the record reflects.
Can you speak real quickly to this tactic of taking
judicial notice? Well, there was something I missed. I expected more to the sentence. Taking judicial notice that what?
Or let me just rewind it a tiny bit then. Here we go.
You're all going to take judicial notice that you've been arraigned if that's what the record reflects.
Your Honor, take judicial notice that you've been arraigned as the record reflects.
Yeah.
Is that what it sounded like? Okay.
I'm going to take judicial notice.
So, again, he's raised a point of error, and they're simply trying to reassert the error. And they don't want to have a discussion about it. They're simply saying, let's just take a judicial notice of it instead of addressing the discontent, the trouble, that's there. So was this the prosecutor or was this the judge?
That's the judge.
The judge.
Yeah, this judge was feigning surprise. I'm sorry, but you don't go from, oh, wow, you haven't been arraigned, to, you know what, we're just going to note you as arraigned as the record shows. In 30 seconds?
That's her tactic all along, is to just take all of the blame and shove it on, well, it's in the computer here. So
it's and furthermore, all of the fallout from that, it's not an error, or it's not. They don't even care if it's an error. They're simply letting the document dictate reality, and that's, of course, how they want to perceive the world.
Right.
Because that way, if they get the document down, error or not, they act on the document rather than right, wrong, or reality or anything.
And even in the previous hearing, a judge was like, well, it says here you signed under threat of violence and duress. However, you signed it acknowledging it and then just moved along.
Well, you notice how he's saying signed and signed and signed, and not contending with the problem with that word.
Right.
but shoving an additional assertion into the mix of signature, which implies, of course, agreement and so forth, which was exactly the point at issue, is that it wasn't agreement, it wasn't signature, it was simply, autograph at best, and nothing indicating a meeting of the minds or a free exchange or an intent to be bound to a consequence or anything like that.
It was straight up to avoid jail, so even worse.
It was not just jail, but jail without justice, right? No jail without reason. I mean, obviously, if there's a cause to throw you in jail and you can make an agreement to avoid it, it's a whole different matter than if there's no justification for throwing someone in jail and they're doing whatever ceremony to avoid it. A whole different topic, right?
And there is no, not that I've ever heard, correct me if I'm wrong, but I have never heard a charge where you get thrown into jail right then and it's like 3 days or 7 days. The minimum is 30 days, is it not? Do they have a smaller anywhere sentence than a potentially, they may not ever go that full amount, or very rarely rather, but do we have a scarier minimum than 30 days?
Yeah, that's, the way they hand out jail sentences. It sounds like if they're not talking money and they're talking jail, they usually don't go for single digits. Right. But maybe somewhere.
It's just weird because whenever they bring that out, of course, that's never part of the conversation. It's always left a big scary question mark. Are we talking hours or 30 days with this threat?
And supposedly that's a part of the information you should have when entering into, think about it. If you heard a charge was having you face 40 years in jail, the amount of money you would sacrifice to a lawyer if you were going that route would be very different than if they said, we're going to throw you in jail for 5 hours.
Right.
And that's a very important part of the information about what you're charged with, how serious it is, and all that kind of stuff. What they're proposing as a punishment.
It's also beautiful, too, that, like, detectives, cops, are supposed to do this whole Miranda right thing before they ask you questions where you could incriminate yourself. A judge in open court, even traffic court, of course not. They can ask you a question. You even say the first wrong word, and they can throw you in jail with up to 30 days and get away with it 100%. So, what is Miranda really? I'm not opening a can of worms, but
there's a discussion I had the other day about fighting rights versus offered rights versus rights that they actually kind of push you to have. The Miranda reading is kind of a pushed thing. It's a fighting right not to incriminate yourself. There's an interesting Supreme Court ruling where they mention moral suasion and honeyed words, right? Where it's talking about you have to fight for your right to not incriminate yourself. They can threaten you with jail. They can they can take it all the way up to that line supposedly of threatening you with violence, but not including threatening you with violence itself. They're supposed to stop shy of such things. But they've really, we've of course seen people who were in fact clearly threatened with violence, almost as vile as saying, if you don't do this, we'll hunt down your family or something. You're going to stop shy of that just because of the tastefulness problem. But
there's a primo example coming up here.
Okay.
You're going to see it. Just real quickly, a big picture, just for any listeners, I guess what big picture is going on here is they have goals, boxes to check. That's to get the plea and to get this waiver to the assistance of counsel. To get the signatures for, yes, we're in charge, yes, you're officially in the system, yes, we're moving forward. But those two things are critical. So a lot of the times their attempts to get on their path are the path of those two things, the plea or the waiver to that assistance of counsel thing.
And really a lot of these minor things in the beginning that seem so benign, they're just ceremonial, I'll read you the charges, grab a plea. They're really where the whole battle is. The real ethical, logical battle, they want to minimize, and then they want to make a huge ceremony of the cleanup process where you've already shot yourself in the foot and they're just drawing out the problem that you're left with that, with taking you through a trial where one of the main things that would be easily, that would be a main thing you would want to contend is already kind of a past problem. And then making huge work of the details of proving that you were on a street. Silly, mundane things like that.
Yeah. Oh, they would like. Sheesh. Here we go.
Objection, point of clarification. How can you say that I've been arraigned when I've not been informed of the cause and nature of the proceedings? Taking judicial notice of the record once the record reflects. Is it not? Record reflects that an arraignment did occur, so I am finding that an arraignment did occur. Objection, point of clarification. I understand that I have involuntary plea.
Are you saying that I entered a voluntary plea?
I'm saying that knowing our voluntary plea was entered on your behalf. A plea of non-guilty was entered on your behalf.
Let's this might have just been a flub. A knowing and voluntary plea was entered on your behalf.
Yeah.
So she's saying that whoever did it on his behalf was knowing and voluntarily acting.
So the judge did it.
It's good to know that the judge, was a voluntary participant in that.
Thank you for telling us the judge was knowing and voluntary when he forced it on him.
The insanity of that statement. I mean,
it's even insane if she meant that it was Robbie who was informed involuntary. If he was voluntary, why would he have to have someone else enter it on for his behalf? He could just do it himself if it's voluntary.
Yeah, that's the way the sentence is constructed, though.
Right.
She said what she meant, I think, but she was trying to apply quite a bit more. She was trying to get him to unlatch from that knowing involuntary and get his head spun around into thinking that what she was finding was that it was knowing involuntary on his behalf.
Right. So obviously judges screw up big time with their little words too. That was a doozy. That was funny.
I think she was trying to get his head spun around because she didn't say anything untrue. It just isn't worth anything.
Well, at best, she said something kind of ridiculously obvious. Obviously she's not insulting the judge and saying that he could be anything other than voluntarily and informing when he enters a plea on someone else's behalf.
Right. And even in any instance, a judge saying, if a judge officially decrees you to be informed, it doesn't actually make it so. The reality is either he's informed or he's not. And if he has a question on the table, that demonstrates that he's not informed. If he has a question about the cause and nature of the proceedings on the table and trying to get an answer, that demonstrates that he's not informed. And a judge declaring it so. If you come in a red shirt and the judge decrees that you're wearing a blue shirt, reality doesn't change.
That's so
the lawyers' behaviors will change. They'll suddenly start hallucinating, I guess.
That's a big inner flipping switch to change, in my opinion. That reality doesn't change. Because right there, when I hear things pile up like that, a lot of people they kind of get a little intimidated and are like, uh-oh, this isn't going well for me.
And they're like, I guess I am informed. Right. It's like, no, what the judge set aside, do you have the information that you asked about? Mm-hmm. It's like, oh, crap, I forgot to get that.
And knowing that allows people to be more confident when they're like, no, and calling it out. And it's just more
careful difference. And the careful difference is they don't want to say you won't be informed. That this they're trying very hard to avoid saying, we're not going to inform you on this point. They're trying very hard to sidestep and say, you're not going to get this information, or this information isn't relevant, or we decree that you already have this information, which is absurd, which is kind of what's going on here. Right. It's like he has a simple yes or no question, and they're decreeing that he already has the answer in order to get the question to go away, which is just insanity.
Oh, yeah. All the while, Robbie probably puts 20 clarifications at him, and I have yet to notice one that was actually answered with a yes or no. It's always answered with a different answer to another question. Mostly
right. Change the question.
Yeah.
Answer.
And
it's like they are hard of hearing. It's like a child.
Oh,
like,
for sure.
Ask a little kid if they took the chocolate, and they'll start telling you a story about a less and less related event.
Yep.
And I gotta hand it to you, because when I'm even just listening to this, I know that on minute 30, 35, 40, I'm gonna start to get frustrated. I'll start to get frustrated. Columbo's gonna start dropping away. And what I'm just pointing out is Robbie that voice is fresh and clean on minute 45 as it is minute 1. And it's awesome to see, because knowing that a major tactic that they use is to, like a cheesy car salesman, just wear people down and get them to quit and get them to frustrate them. It's all part of it. And to see him like be immune to it, it's like he's immune to it. And yet the battle goes on, and it's them who get frustrated to the point where they like, I can't win other than threatening this guy with violence, and that's what happens in the end.
Every time.
Yeah, props. All right, here we go.
And later withdraw or change that plea. But that's I'm finding I'll write a minute order after that.
I would object to that because I have made it very clear that my intention is to enter a guilty plea.
Then you can change your plea to guilty plea at a different time.
Am I allowed to make a plea in the first place?
So let's talk about deliberating occurs or time's out.
Objection, we have not.
I want your objection for the record.
I have not entered an voluntary plea at this time.
I want your objection for the record. You need to be quiet all the time.
So if you could pause it for a moment.
Yeah.
Now, you see the strategy going on is that I'm thinking about how this is looking in a written transcript, right? She is talking on top of every sentence he's trying to say. Yep. She knows the point he's going to make, and she knows it's powerful.
Yep.
So she is trying to talk over the last half of every single sentence.
Yep.
And again, dirty pool. It becomes obvious. She knew exactly. I mean, no, this feigned ignorance about the whole ordeal. I don't really buy it at this point, because she's giving not an inch. She's not letting him hardly say a sentence at this point. She's talking on top of the sentence in order to change the topic, in order to force it to be changed.
Yeah, and her tactic, we just went from judicial notice to, it's on the record. I'll put it on the record. You need to be quiet. So
and again, having something on the record does not resolve the problem.
Of course. It's
not just you put your complaint in the complaint box. Yep. Now go ahead and take your screwing. It's here's a problem that causes us not to be able to proceed logically.
Yep. And all she can respond with is be quiet, step number 1, and then be quiet, step number 2, which is noted for the record, sweep it under the rug. It'll never see the light of day again.
She's making sure she's saying that before he's got his sentence out. She's keeping it from being noted for the record, right?
Yeah. Yeah.
She's saying that it's noted for the record. She's stopping his sentence short.
The interrupted sentence is noted for the record. Move on.
Which is useless for the record, for any kind of a constructing the logic and pointing out that she had no excuse not to know these things that you're saying, because she's stepping on your sentences to keep you from getting it out.
Yeah, I just want to yell out, "Stop interrupting me!"
I know. And so addressing that can happen, right? Objection, point of clarification. How can we conclude any meaningful business here today if we're not allowing each other to speak full, complete sentences? May I be allowed to speak a sentence, yes or no? I don't know.
I can't stop you very well because you have armed guards.
Yeah.
But it's becoming clear that I'm not being afforded that same ability to clarify even. We're not even talking about, you're not even into the point of making an assertion other than clarifying a couple errors. The assertion that you have is that errors were made, that there are things in the record that are misleading and that are that shouldn't be in the record because of that misleading, misleading quality. That's it. And she's not said it's not misleading. She's very, very deliberately going in a different direction than to say, oh, well, this appears to be true. She's saying, true or not, it's the record, and we're sticking with it.
Right. Now, you need to be quiet while I say a bunch of things that are going to bind you and impose upon you.
Further screw up, this supposed record, which is no longer a record of actual events. It's just a record of her delusions.
Sure. Yeah.
Oh boy. Okay.
Hopefully this will end up in her medical file somewhere under, mental illness issues. That would be funny if that ever happened. Here we go.
Let's talk about your decision to have an attorney or not. Today's the day.
So we just moved on from the checkbox of plea to the checkbox of let's talk about this waiver and the assistance of counsel issue. Interesting.
I will make that decision as soon as I get the ring and asking how the
You can make that decision now.
has the prosecutor submitted any evidence that the court has jurisdiction to impose upon that verification item.
The court has found, based on the arraignment that has occurred, there's jurisdiction. You need to make a decision right now.
Objection.
Listen to me.
Before she throws up this threat, go ahead, Gary.
There was a lot there, and I didn't catch enough of it.
Oh.
She was speaking quickly. Say it again? Or could you tell me the gist of it?
Yeah, she's okay. I'm just gonna play it again and stop it and then say it quote.
Has the prosecutor submitted any evidence that the court has jurisdiction to impose upon that verification item?
The court has found, based on the arraignment that has occurred, there's jurisdiction.
The court has found, based on the arraignment that has occurred, that there is jurisdiction. You need to, and she's about to say, make a decision. Here we go.
You need to make a decision right now.
Objection.
You need to make a decision right now. He objects, and she goes, listen to me. This is more, be quiet. So that's what she said.
Well, yeah, and I understand why he's stepping on her sentence, because she's already said a big old long stream of things and is about to continue on that stream,
Yep.
but without taking a moment. She's not taking baby steps. She's trying to cover a lot of ground
Oh, yeah.
in order to be dishonest. It's not trying to cover a lot of ground because
Yeah.
because it's mundane. She's trying to cover that ground because she wants to pull some crap, right?
Yep. Bind him to it. And then she won't even let him.
Say, here's what's going on. Next step. Here's what's going on.
Yeah.
She's trying to say, don't interrupt me. I'm not taking a breath. I'm going to say these 3 paragraphs without a breath so that we can be 3 paragraphs down the road.
And that you can't object when it's appropriate to, which is part of a fair hearing.
Right.
So.
Yeah, and she's using the arraignment as evidence that the court has jurisdiction when I challenge the legitimacy in the first place. Yeah.
Yes, the arraignment that is on record, but not in any meaningful sense happened.
Right. You don't even have a transcript of it, because if you did, you would find out that I only did that to avoid jail. Like you're probably...
Yeah, she's going on the fact that there was a note in the file that says arraignment check.
Yeah, no doubt. So this is as forceful as it comes without actual physically touching people. I mean, this is just Nazi Germany stuff. It's going to happen my way, and anything you say is completely irrelevant. I'm just going to dismiss it and sweep it under the rug. You have no power here whatsoever. I'm just going to go with what the state wants. Screw you. I mean,
a mugging happens without touching anything but the wallet, usually, right?
Yeah.
So that's certainly forceful, certainly violent.
Yep.
And all right, here we go.
Listen to me. I'm going to hold you to contempt. If you don't decide by 11 o'clock today whether you want to proceed as your own attorney or whether you want to have an attorney.
It got fuzzy there, but she's dealing with this attorney issue of, I'm going to hold you in contempt unless you decide by 11 o'clock today, which was in 15 minutes, whether or not you want to have an attorney or waive an attorney and represent yourself. And
we've seen this to be not merely idle threat. We've seen this actually executed. We know people who've been in jail for exactly this demand.
Yeah.
And logic be damned, and any clarification be damned. They're going to get you to choose which foot is going to be shot.
And this is
they're going to get you to choose which injustice you're going to permit. There's 2 roads.
Yeah.
Both of them are hugely wrongful, and they're going to get you to choose, 3, I guess. The 2 they offer, and then the one that heads to jail first, and then back to where you're at.
Oh, so here's the best part. She says, after they come back from this little recess here, that she failed to mention a third option that he had. And that was to accept Mr. What's-His-Face as a legal advisor. Not full-on counsel, that he was still the primary, but that he would have a legal advisor. So she updated her threat.
After having made a threat,
yeah,
she's going to come back and say, "Oh, well, you could have kept your wallet too, or not kept your wallet. You could have left your wallet kind of halfway with a friend, right. After saying your money or your life." that the absurdity of that, and again, waiting till she has kind of the wallet in hand to do so is interesting too.
And I mean, I just want to put a little highlight star on this moment in time, because I don't want people to ghost past this sentence. When a judge says to you, whether or not she's some young 30s woman who's just an ex-prosecutor, who full-on pawn for the state, when she says, "I'm going to hold you in contempt unless you choose option A or option B," that is highly offensive, and I get offended at very little, and that just makes my blood boil. That is the stuff that really makes me, if that woman gets punched and knocked out dead in the face, stone cold onto the street, it wouldn't make me upset. That is extremely violent threat.
Yeah, that is as violent as gun in hand, your money or your life.
Yes, and just because it comes in a pretty package and a cute little voice doesn't detract from that fact at all, in the slightest.
Not a bit. And this is we're leaving you with two unjust and unacceptable options. Your idea of what's right and wrong. Yeah. And by the way, supposedly the public relations says what's right. We're not going to let you have that. We're going to make you verbalize that you don't want it. How would people feel if some two-bit judge in some podunk town, even the most ardent statist, how would you feel if that judge said, "You're going to waive your right, your Fifth Amendment right, or I'm going to throw you in jail till you do"? How would they feel about that? That eviscerates the concept of right and wrong.
Oh yeah, that's exactly what just happened, though. I mean, and you'll hear it even more egregious up here, Gary. It's like you can either take a plea the way we want it taken, or you can decide to be your own attorney or accept one of ours. But those are your choices, and that's it.
And again, it's not. Be your own attorney implies a whole lot more than just proceeding without.
Well, of course.
Plus, they're getting rid of your excuse to say, "I need to be informed of the cause and nature of these proceedings so that I can find a competent attorney or decide whether I need a competent attorney or whatever." I mean, they're wrestling this option away from you because that's all they can do to proceed past this impasse.
And they're throwing in jurisdiction into it. So that matter's already resolved.
Well, I mean, the fundamental problem that they're trying to get around is they're trying to hide some information. They're trying to hide the fact that they don't have information is kind of it. They're trying to avoid talking about that factor. And he's asking very specifically about that thing. And it's detrimental to their position that either A, you're innocent and want to be there, or you're guilty and it doesn't matter whether you want to be there.
And oh, by the way, if you decide to take this option of taking any kind of a plea whatsoever, or filing a plea, whatever, you have to state on there's included in your signature, that you're doing this voluntarily, that there is no coercion whatsoever.
Yes. He or she is absolutely saying you will lie.
You will lie.
One of two choices, one of two manners. You will lie in one of two manners or be thrown in jail.
Yes. That is the digging to actual blink bottom I want to get to. They are forcing you to make claims when we obviously don't want to do that. We just want to clarify theirs. You will make a claim. They will bully you while they're doing it, make you claim for a forever record that you were not bullied, or they'll bully you by throwing you into a cage for up to 30 days.
And granted, it's not like most lies. Most lies, you're trying to victimize somebody else. They're trying to make you lie where you're the victim of the lie.
It's the sophisticated hustle.
Sick and twisted.
Disgusting. All right, let's go ahead and get a little bit more.
All right. This is
a great
I listen to this, and this is where I go, oh man, this is where I would start to get off Columbo. Like, I need to head check moments like this and stay in the game, Maverick. Anyway, here we go. This is just intense.
I'll give you a direct order that you need to make that decision in the next 15 minutes. Well, if you fail to comply with my order to make that decision in the next 15 minutes, you either proceed pro se or you get an attorney appointed to represent you, then you're subject to being held in contempt of court and going into custody.
Are you finding me the opportunity to de-arraign and be informed of the cost and nature of this proceeding?
We discussed that, and I have found that you have been arraigned.
Can you tell me how you found that, what actual evidence you found?
So I just want to pause it right there because Robbie went with the let's question about the arraignment when the threat that is on the table with your jail on the line is about this wait pro se or accept one of our attorneys, but either way jurisdiction is built in there. So I guess what I'm saying is,
Well, not jurisdiction. I mean, you don't actually change whether or not they have jurisdiction. You change whether or not you're challenging the jurisdiction.
but in this case, when you see him, when he goes to this little room with the prosecutor and the attempted defense lawyer, the prosecutor tells him that in order to make a plea, you have to voluntarily submit jurisdiction.
Right. Well, yes, there is a perspective of it. The personam area.
Yeah.
The personam subsection of jurisdiction.
And then
there are others that you can't waive, agree to. You can't alter the status of jurisdiction on the other, on
Sure.
standing and subject matter and so forth. You can't change the reality of it or the
I guess they just
implications of it.
piggyback into.
But there's another point.
Huh?
But there's one more aspect here.
What's up?
So she's saying that you will choose A or B in 15 minutes or go to jail.
Yeah.
Now, even within their public relations, there's a slew of rights in their public relations that he will be waiving in 15 minutes. Right? That he is forced to waive. If that makes sense as a concept, right? That he is being threatened to waive under punishment of going to jail. And keep in mind, contempt is indefinite. I mean, if she says you will choose A or B or go to jail, he will be in jail for the rest of his life if he doesn't choose A or B. He could be, I should say.
Well, it's because going to jail is giving up the right to the pursuit of happiness. That's one
I get that.
they're going to try to respect.
No, what my point is it's not a punitive. It's not like, okay, if you don't waive one of these rights, if you try to stay with your rights, you'll be punished by going to jail for a certain amount of time, and then your punishment for that will be over. No, it is you go to jail until you relinquish your rights. The public relations rights. I'm not advocating the idea of rights necessarily,
Yeah.
but it's not that I sentence you to 3 lashes and then you can continue on with your questions. It's you'll be held in contempt, and the only way to correct that is, again, habeas corpus proceedings, which horrible bureaucratic mess they've made of that, or choosing, you just wait in jail and choose later anyways. It's shoot yourself now or shoot yourself later,
Well, sure. I guess what I'm saying is they say you've got to represent yourself or get one of our attorneys or give up your rights to freedom. So in all 3 of those, there are rights lost.
Give up your rights to freedom and then do so anyways.
Right. So it's pick your poison. And don't question it, don't challenge it. If you try and challenge it, we'll call that, oh no, you're contesting it, throw more BS at you, and just anyway, it's just endless. It's funny to hear this way this is going down.
Yeah, and as this is happening, she's getting up and going toward her chambers because she said that the record is off. So even when I try to bring up the fact that she's forcing me to make this decision under coercion and duress, she's like, well, the record's off, so the record
that doesn't exist as a concept, though. There is no such thing as off the record everything that occurs in reality actually occurs in reality.
Yeah.
You know, it takes a lawyer to pretend something didn't happen just because it's off the record.
And she's pretending that she's not saying, you are not under duress or coercion. What are you talking about? She's saying duress and coercion isn't even a problem unless it's on the record. We're off the record now, so go away.
Yeah.
Insanity.
All right, here we go.
Additional notice, do you have factual evidence that I have been arraigned?
I will take additional notice of record that the court reflects that you were arraigned.
So you are relying upon opinions that I have been arraigned?
Yeah, I'm just observing someone. You're just observing someone.
Okay, there was a voice going on that says, oh, I'm sorry, I'm just observing. Now someone is questioning whoever.
Yeah.
Okay, what's going on here, Robbie?
Well, I don't really know. All I know is that clearly, well, at almost every hearing I've gone to, somebody ends up coming around and like asking people in the audience if they're still there for some hearing or whatever, because they're trying to figure out like why a person is there, presumably in case this person thought they had court that day and they just want to clarify that. But
It's
I don't
a
know
process
that.
of elimination to see who's there to help you.
I think so.
That's what this guy's getting questioned, and she's like, you know, what are you doing? He's like, oh, I'm just observing. So here's that.
Court setting recess for 15 minutes. And then that time will be for waiver of counsel.
Judge, I do not wish to either make a decision.
I'm ordering that you make a decision.
I know a lot of this is inaudible. She's trying to rush off saying that they're in recess for 15 minutes, and he's trying to keep her there and pin her down.
By 11 o'clock today.
And
We're going to go off the record. You're going to do the document for waiver of counsel.
under what authority are you ordering?
Can review it.
Under what authority are you ordering me? That's a digging to actual reality question.
We don't do it, then I'm going to be calling the nothing to take it.
Has the prosecutor submitted evidence establishing jurisdiction and imposed upon?
She threatened him again. If you do it or not, if you don't going to do it, I'm going to have the deputies take you into custody. And he hits her with the meat and potatoes about the prosecutor submitting evidence.
Can you let me know what that evidence is?
Just sit down and review that piece.
Can you let me know what that evidence is? And she says, you can sit down and something. So just forcing him to be quiet.
I will not be able to make a decision unless I get an answer to this. Also, I have the motion to dismiss.
I'm giving you an answer. You can file your motion to dismiss after we discuss your issue with the attorney.
I have filed a motion to dismiss.
Okay,
And
we can discuss it.
I cannot make a decision about an attorney until.
We'll discuss it ahead. No, you need to make that decision.
So you're forcing me under duress.
We're not on the record to show that it's under duress and it's not under duress.
It is under duress.
I don't know how you keep your cool. I would be flirting so hard that she would have threatened me with one more word. I couldn't have kept my cool like that through that whole thing. That ego especially comes in when it's just a little girl compared to me. I just can't take it. So good job.
And now the recess happens, and it's a little bit of a confusing time on the audio, but you'll hear me like talking to the prosecutor and also turning to the audience and saying they were all witnesses to the crime that was committed, and then a bunch of people are laughing and making jokes and stuff. So
Yeah, and I hear all of that. So, but parts of it are inaudible. So as best you can, have me pause it at any time and just play narrator or whatever if you want to.
okay,
Here we go. So
Yeah,
recess.
if you have any questions?
Okay, yeah, I'll do that. Who is this that just introduced herself to you?
Well, that's Jenna Plank, the prosecutor. She
Okay.
wasn't there for the first part of the hearing. They
Oh,
they
that's
had
right.
a different prosecutor
Okay.
in there for some reason.
So now she is here. Interesting. Okay.
So if you hear that I'm being coerced and threatened with violence if I don't either make a decision to have anything or with you.
If anybody has this hard to hear, let me know. I'll repeat it.
So yeah, just girls.
This is kind of inaudible. Not much to pick up. You're just updating Jenna on what just happened.
So what I asked is to give you a copy of this what I believe you call a motion to dismiss. That states in there the evidence of why I have not been arraigned or why this case should be dismissed. However, I still intend to make more
So you handed her a copy of the motion to dismiss or brought it up, and you're just repeating the various violations that you want her aware of.
Yep.
Yeah.
And I'm not sure why you guys are saying on the record that I haven't not been knowing about this.
So summarized was, why are they doing the arraignment without a voluntary plea? And coming up here is a lot of the laughing, right? A lot of the, it's almost like kind of creepy, like these lawyers, there's a lot of tension in the room, and you know, she's there, her assistant's there, and it's like they need to release the pressure and the relevant points you're bringing up about how the business goes on there, when everybody already knows it's just nothing but a bully, right? They know that it's the judge's way or no way. They live by it. And they like laugh and kind of blow off the steam, and it's like this way of reinforcing each other. It's like, yeah, we're all in the group that laughs at stuff like this. Ha ha ha. It's just, it's like this bonding experience. It's crazy. It's crazy. But,
yeah, they just see. Oh, sorry. Well, I was just going to say they laugh like jackals in the lion's den,
What were you going to say,
Gary? They probably see these efforts to get at the ethics and reality of the situation as just hopeless, right?
Yeah.
And as pointless. They like what?
Fantasy.
Yeah. Frivolous. They like the word frivolous, don't they? It's
frivolous.
Like right, wrong, or indifferent. It doesn't matter.
It's nonsensical.
You're here to play this game, and all we need is the check boxes. And your fight is going to land you in jail because you'll be choosing A or B one way or the other.
Yeah.
This fight, why even mention the gun when the mugger's holding it?
Right.
Why you just act like you act like you're giving them the wallet because it's dangerous to do otherwise in their mind. And in their experience, that's true. Any mention of a judicial impropriety tends to get real bad for a lawyer. What right, wrong, or indifferent, you put up with it, and then you hope to clean it up later.
Yeah.
Of course, they don't really care if they clean up later. It's their client rather than them that's in jail.
Yeah, and they still get all the money.
Right.
Anytime I don't know, you get exposed to like this group mentality where it's obviously so crooked, it just reminds you, like all growing up, my generation was like the two most admirable things you could grow up and become were a doctor or a lawyer, a doctor or a lawyer, a doctor or a lawyer. Lawyer is one of the most crooked things you could ever be. I mean, they pretty much run the country, more people in Congress, blah, 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 and law. And then doctors, obviously another totally crooked-ass industry where they're just basically legalized drug dealers. So it's just, that was the cool thing to be, and that's actually two of the most insane industries to be a part of, the way they've got it, so...
Yeah, and this group mentality and the way they laugh is really the reason why I need more witnesses on my side.
And it's good to see, well, not see, but hear the fact that it doesn't shake you. It's like they're trying to be straight up out of high school. Like, what is this? Are you all laughing and trying to think it's actually going to put some kind of a social pressure on me or make me feel awkward or intimidated by any of you fools. I can beat any of you fools in this open court if they would stop interrupting me and threatening me with violence and showing you all the bias. But they won't, of course. If any of you doubt me, open challenge anytime. Do you want to start right after this hearing? I could. Let's record it. I haven't been to law school in a single day, and I'll beat all of you combined.
It's not as if they're just looking at him as, oh, he's just mistaken and foolish, because there is no sense of, well, let's just simply explain your error. They know he's perfectly right on the money.
Yeah. Oh.
About the violence. It's just that they're viewing it more as frivolous.
Yeah.
Or fruitless, I should say, rather than incorrect.
Fruitless rather than incorrect. Yeah. Yeah. When you said they kind of know it, there's this defense lawyer. He's trying to get on Robbie's case here, and it's funny the way he talks is it's like he almost has a Freudian slip, and then he'll catch himself and restate it in bullshit terms. It's like you can hear the truth come in, occasionally it starts to slip out, and then he catches himself and goes, oop, that was a dangerous road, and then restates it, inserting in the legalese bullshit. It's hilarious.
It's funny, though. I mean, people aren't always aware of their subconscious protecting their ego.
Right.
Like, I've seen people who aren't aware of themselves stopping, their subconscious stopping them from treading right where you're wanting them. It's like, you know where you're trying to bring the conversation, and boy, they just, like right before you walk out onto that plank,
yeah.
Something in them tells them to just change topics.
Yeah.
And it's not even, it's people who are trying to maybe be sincere do it. And so I know the lawyers who, I don't know if sincerity is really a part of it. They would know better.
Yeah. And I just wonder if it's kind of like they justify it in their sick little heads by going, yeah, we know the arguments that could be made by anarchy type people and how some of them could sound like they have some kind of, moral understanding with the weight of public opinion. But these people are just disempowered, disaffected. Life didn't work out well for them, and it's worked out well for us. And to protect that, the system that works well for us, and not people like that, then that is part of it's just like the belief in a religion, right? This religion must be correct in order to justify what I am and what I do and all what I consider to be, blah blah blah. I don't know, man. It's just crazy. It's just dark ages. 21st century dark ages. Here we go.
Don't think that I can't get a copy. I think she's messing. So what I will do is I'll let you know that the only reason I put it on this board is because I live in the rest snap right behind that side. So I will autograph it. And then I'll likely like this. Mr. Stepper, that's very good. Actually, my initial all these things. Yes. Well, everyone in here can serve as a witness, and I'm filling out this form under duress and threat of violence. I don't need duress, so I'm
That was interesting. Who was it that said, well, I don't see any duress, so I can't witness it?
Yeah, that was another lawyer.
Good.
And it's technically true, but being glib, of course, right?
Of course.
Because duress is an internal feeling, right?
Oh, yeah.
I don't see it. The fact that it pressured you is internal. But, the threat of violence is there. You can see that I'm under duress, and they're saying, well, we can't witness that.
So Robbie's pointing to...
They're witnessing that you're proclaiming that you're under duress.
Right.
Right, throughout.
He's pointing
Yeah,
to
and-
the act, the autograph too, and she's interpreting that and just pretending like, oh no, it's the internal feeling that is what he intended.
Yeah, and at this moment, two attorneys walked out of the room, and then that attorney spoke up and said that stuff.
So
This attorney, I later see her on her cell phone using Facebook, and I actually ask if cell phones are allowed to be on. So I just trolled her a little bit after.
Oh, okay. Funny.
Well, it's a fine point. You know, it's like there is a separate class.
Oh,
You know, your opposition is welcome to use. You would have to go all the way outside to get the same information. He just needs to step out the room to get, right?
Yep.
It's making sure you have bricks tied to your legs while you're trying to have a supposedly fair race. Not even fair. You're supposed to get the upper hand. You're supposed to be presumed innocent.
Oh,
Yeah.
But anyways.
How dare you even speak such nonsense? Get that out of here, Gary. It doesn't belong here. Oh, so you said, oh, you all can witness to me doing some dress, whatever, and here's where some laughing begins.
If I don't do this, then she'll throw me in a cage. So that's your problem.
One of them said, that's your problem.
Yep.
Interesting.
That's your problem. Again, confessing that he's fully aware
Oh, yeah.
of the situation. He just doesn't care. I mean, again, a huge example of just dehumanizing dehumanizing someone to a point that there's only one comparison, and you know, you hate to make it because it's supposedly the end of all discourse, but you know, these guys need bigger boots. Let's put it that way. Shinier black boots.
Yeah, no doubt.
I
I have no dog in this fight. Okay.
have no doubt it's better process. Calling back. She's like, this offense is going to come in here. She's like, we know it's exactly how that's going to happen.
I'm not sure what's going on there, but it's funny from that same lady that that goes, you know, I can't see your dress, there's nothing up there, and then I have no dog in this fight, and she's all laughing and everything. I mean, she had no dog in the fight, then why are you opening up your mouth? Why aren't you saying anything?
She obviously wanted to play the court jester.
Oh, yeah.
You know,
Yeah.
but she just wanted to say that you know, oh, I can't help you, but I can ridicule you.
Yeah.
You know, it's like,
I'm really glad this got recorded and that we're going over it, because this is most definitely a puzzle piece to any standard quote-unquote hearing when you get this far down the rabbit hole with them.
now here's the sickness. This is a defense attorney, right?
No, isn't this a
Not
prosecutor?
yours, but this is one of the defense attorneys, right?
The one who's laughing, Robbie, isn't that on the prosecutor's side?
No, the lady that said that I don't see that you're under duress and stuff, that was somebody else's defense attorney.
Oh my god.
How sick is that, right?
Oh my god.
Yeah, I thought I'd done that.
That's extra sick. Oh wow.
And before this happened, she actually told her client that, oh, this guy's really good at defending himself.
Well, I mean, it's still true. It's just you're good at defending yourself up against someone who doesn't want you to defend yourself.
Well, she might be saying that too, knowing full
Challenge
well
us.
what's eventually going to happen, and then setting him up as, oh yeah, this guy does a really good job of defending himself, to help convince her guy that this is what defending yourself gets you.
Yeah, that's true.
Even if you're good at it, this guy's going to get steamrolled. Watch this. And she doesn't say it that way. She's like, oh
True.
yeah, this guy's good.
And again, that is the overall impression that the whole bar association is there to push, which
Right.
is, you know, right, wrong, or indifferent. If you're by yourself and don't throw money at a lawyer, right, wrong, or indifferent, you're screwed.
And you're a fool. You have a fool for
And
a
you're a
client if you're representing yourself.
Well, I kind of agree with that sentiment and the
Because
idea
it
that you
says
can represent yourself. But again, challenging is different, and challenging
Sure.
in a way that a lawyer is specifically forbidden from doing. I mean, imagine. I mean, if if a lawyer were to bring up these questions instead of just Robbie, that judge would be pursuing getting them thrown out of the bar by this point.
Yeah. Oh, for sure.
And probably successfully so.
And they all must get wind of that somewhere. They know it. You know.